So here we are. I'm going to start. There's a lot about the right to know law that can be, there's a lot of adjectives. I know that it can be burdensome, it can be frustrating, it can be time consuming, nitpicky, all sorts of things. And I'm hoping that this presentation will, one, answer some questions, and two, perhaps make it a little less of that burden. And I'm going to start with a story of an agency that perhaps good intentions, but did not handle this process well. And unfortunately, that in itself became a story. So it involves a school district where an alleged incident occurred on a school bus. And a local TV station heard about it and did a right to know request for the video of the alleged incident. The school district fought this for 7 years. First, they went to it was appealed, went to our office, and we said you need to turn it over, and they kept fighting and fighting it in court. And finally, in 2023, a court said, "Listen, this is the final verdict. Hand it over. You can blur the faces of the students, but this is a public record." So when this happens, being kind of right to know law nerds as we are, we always think, oh, what's going to happen? It's going to be something really scandalous in this video. And so we were curious when it was finally put in the news story by the media. And it was a whole lot of nothing. You could hear somebody say, hey, don't do that, but you could not see the alleged incident. It was very dark. It was in the evening time. So really kind of nothing going on. And it seemed like that would be the end of the story. But then someone did a right to know request for all the legal invoices associated with this 7-year battle. And it turns out that more than $250,000 were spent in legal fees to prevent the release of a record that was deemed public and is also showed basically nothing. And this is not to say that and then at that point, a lot of local TV stations covered and newspapers covered this story. It became a big story because of how they handled it. And this is not to suggest you should not fight the release of records. You absolutely should, particularly in your roles. It's just to demonstrate that being careful in how you handle it is important, in addition to the decision that's being made. All right, so now I'm going to go through a lot of the details, and I imagine all of you are very familiar with the right to know law. So I'm just going to do a quick, brief reminder of the process. So when we talk about some of the issues, it makes a little more sense. So why do we have a right to know law? What's the reason for people wanting to be able to get emails and video recordings and reports? The idea is that the public has a right to see what's going on, how their taxpayer dollars are being spent, and that type of transparency is a key way to hold government accountable for their decisions, both because the public can get access to records and then publicly comment on them or share them or make decisions who they're going to vote for on them. But also, I think because knowing that there's someone watching you, I think always makes you behave a little bit better. If no one was ever going to get any email or that you ever sent, it changes kind of how you approach things. So I think that on several fronts, it's a great, great law. And Pennsylvania is known to be one of the stronger ones in terms of access, ease of access for requesters. And why is that? It's because the process up until you get to the court system is very simple to use and free. You don't need to be an attorney as a requester. You don't need a lot of money. All you need to do is fill out a simple request form to the agency you're seeking records from, providing your contact information and a description of the records you seek. Super simple. And then at that point, the agency has the choice to either grant or deny access or take an extension. 95% of the time, more than that probably, this is where it ends. Request is made, decision is made, nothing further happens. Less than 5% of the time, maybe about 3% of the time, the requester is not satisfied with the denial of access to their records and they appeal to our office. And that's when we have 30 calendar days to hear the agency defend their decision about whether or not they want to, why they feel like they were legally justified in appealing and in denying access to those records. And the burden is on the agency to prove that. The requester can sit back and do nothing if they'd like during this process. So again, the request to the agency, the appeal to our office, all simple and free for the requester. Then less than 5% of our decisions are appealed to the courts. And that's when, oh, it's free and it's quick. All that goes out the door, as I demonstrated. It can take years for something to wind its way through the courts. There are court fees to file. And most requesters at that point would probably want to hire an attorney to help them manage the court process. So it's a quick overview of the process. Couple reminders of things I mentioned. You have 5 business days to do one of the 3 things: grant access, deny access, take a 30 calendar day extension. It's pretty liberal reasoning for that calendar day extension. You have 5 days goes by real quick. And basically, unless you have that record right there, you know it's public, you probably need some time to review. You need to, maybe someone's on vacation. There are a lot of reasons to take that extension. And then it's 15 business days after the date of the denial that someone can appeal to our office. And note, it's not just complete denial of records. You can, if you think an agency over redacted a record, you can appeal the redactions, and you can also appeal the fees. In Pennsylvania, the only time fees are associated is if you have to photocopy it. If you are able to prove that we only have hard copies of it, or if we have electronic copies, but we have to redact and we don't have redaction software, so we need to print it out and, strike it out. And once in a while, a jump drive, like if you have a lot of data, and then very rarely an agency can prove they need to buy special software in order to provide the record. But in some states, they can charge hourly labor rates for records requests, but not in Pennsylvania. And as I mentioned, when it comes to us, most don't. The requester doesn't have to present evidence or any arguments, and the agency has to defend their reason for denial. And we have 30 calendar days to issue our, what we call a final determination, which is legally binding unless it is appealed to the courts. A couple things that I want to point out. There's no ban on frequent flyers in the Pennsylvania right to know law. There's nothing in that law that says you can turn someone away because they keep submitting requests. In theory, they can make a request every day if they would like, according to the law. There's talk about perhaps changing that. There's always talk about changing that, but that is the current law. We also cannot require someone to disclose the purpose of why they're asking for these records. You can ask them and they can provide it, but you cannot require them to disclose it. But here are some things that you all don't have to do. You don't have to create a record that doesn't exist, even if maybe in theory the record should exist. The right to know law has nothing to do with retention. If a record that should have not been deleted was deleted, we are silent on that, the right to know law. If there's a record that maybe there's minutes from a meeting that should have been kept, but they were not kept, if it doesn't exist, it doesn't exist, and you don't have to create one. If someone wanted a summary of how Liz Wagenseller handles presentations and I don't have one, I guess I could do it if I was wanting to, but I don't have to create that record if I don't want to. You don't have to answer a question. Why did you put a stop sign at that intersection? Seeking records. You don't have to conduct legal research. What gave you the right to do this? And you don't have to provide an electronic copy when only a hard copy exists. They have to accept it in that form. You can scan it in and make it electronic if you don't want to go to the trouble to collect 50 cents for 2 pages, but you don't have to if you don't want to. Now, in terms of records, back in the day, a record was a pretty simple thing. It was a file cabinet with a bunch of papers. Now a record can be anything. It can be a text message, an email, a Facebook message, a LinkedIn message, and it can also be on your personal devices. If you use your personal phone for agency business, the text messages you send about agency business may be subject to the right to know law. No one can hide behind Gmail and do all their business on Gmail and then not be subject to the right to know law. So that is all fair game. Moving communications to a private device or a private account does not change anything according to what the courts have said. And another thing I always like to say about this, so even if you are on your personal device, don't put anything in writing you wouldn't want to see in a headline. And I'm going to go west to another state to kind of share a story of why this is a dangerous way to go. In case you don't know, this is a picture of beautiful Red Rocks, an amphitheater in Colorado that is one of the most picturesque you can go to. I've always wanted to go, never been. One day I hope to get there. And a little fun fact about this is even though it is not in or adjacent to the city of Denver, it is owned by the city of Denver. It is something that they own and operate. And a few years ago, there was a concert and there was a hailstorm, and the hail was very large and it struck people in the head, leading to injuries. It was a big story. And the local newspaper, the Denver Post, did a request for records associated with how city officials communicated about the event and how they communicated right after the event. And the city fought release of those records. They said, well, they use their personal cell phone, texting, so I don't think we should give those records. And the Colorado judge said, nope, you have to turn them over. And this time there was a little bit to be seen, and it was on the front page of a newspaper because what they said were after the event, the next event, they're making jokes about it. Oh, someone said, are they wearing helmets too soon? Ha ha. So you kind of see why they were hoping not to have that be out there in the public. So this is kind of a twofer. If it's you're using personal devices, it doesn't necessarily shield you. And always think about if you'd want to see something like this on the front page of paper. Now, when you get a request, there are 3 hurdles you want to go through. And if you say yes to one, you go to the next one. And the first one, does the record exist? Obviously, that is something that is pretty critically important. And that is the most common reason that records are denied in terms of appeals that we see. The agency says, we don't have that. And it's either that it never existed or it was deleted or you are at the wrong agency. So that record doesn't exist. We get a lot of requests for our office because we're called open records for birth certificates. And we definitely do not have birth certificates. So once you establish it exists, is it a record of the agency? And conversely of kind of what I said before, just because you're using an agency email, it doesn't make it a public record. If someone in my office sent an email around saying, my daughter is selling Girl Scout cookies, I left an order form in the break room, please fill it out. And then someone did a right to know request for that email about the Girl Scout cookies. The Office of Open Records is not about do-si-dos and Samoas and all that. So we could deny that and say it's not reflective of agency business. It's not a record of the agency. There's an infamous case, my gosh, going on 13 years ago involving former Attorney General Kathleen Kane, who had found that there was some agency devices, agency emails, people using agency emails to exchange pornographic emails. And the judge said, as awful as that is, that exchange of pornographic emails is not the purpose of the Attorney General's office, so you don't have to provide those records. So if you do, it is a record of the agency, is it a public record? There are a lot of reasons, particularly in law enforcement, as to why a record may not be public. So until you clear these 3 hurdles, you don't know yet if it's going to be should be released. What is public? Just a couple of things. The financial records are almost always public. I have yet to see one where someone is able to prove that a contract or another financial record is something that can be protected. There was a case where an international corporation we've all heard of had a contract with a county and someone requested the contract. And this corporation got involved and said, no, we put a lot of trade secrets in that contract that we don't want our competitors to see. And our office and the court said, like, that's too bad. You shouldn't put them in there. The public has a right to see how taxpayer dollars are being sent, and contracts are at the heart of that. Now, sometimes in a financial record with a law enforcement, there may be secure things, but that is the exception and not the rule. And then aggregated data, because you can't identify who it's about, is often public. Now, one funny story where whether or not a record reflects agency business. A handful of years ago, someone got, I will give them kudos, a pretty good idea. They did a right to know request for the playbook for the rival football team's high school team. Not a bad idea. And this is one that I thought, guys, we got to figure this one out, because high school football will take a whole new direction in Pennsylvania, and we will get some interesting fan mail. But we were easily able to recognize that the playbook that the coach possesses does not directly relate to the performance of the district's function of maintaining a sports team. So we saved high school football for the time being. Okay, so that's kind of the basics. Those are the things of the nuts and bolts of how it works for everyone. Now I'm going to dive into the law enforcement aspect, because there are a lot of unique things here. First, I want to share something that leads up to a law enforcement thing. We've had a huge spike in appeals the last few years. It's been kind of ticking upward for a while. COVID and the 2020 Pennsylvania election made a huge increase. And then this year, last year, 2025, was an enormous increase. And given that we have 30 calendar days to make a decision, it can create a real crunch. And to illustrate it, it was more of the end of last year we saw this. We did 62% in the last 5 months compared to the past 5 months of last year. And Sad to say to you all that police departments are a big part of that spike. There have seen an enormous spike here, not enormous, but a pretty significant spike. I mean, that is more than a 50% increase in appeals in police departments. And we sat back and we looked at this. Usually, when we see an increase in, let's say, school districts or across the board, we think, what's going on? There was a little bit of increase in 2021. You can't see 2020, but because of all the protests and police force and all those questions that were going on. And this is happening in other areas too. For townships, why are we seeing an increase? There was no commonality. There was no hot news story or trending topic that could explain it. But here is what is happening. Our friends in AI, that is what is going on with this increase. It is something we have not seen ever before, because this is a whole new world for so many people, and touches so many points about this. What we're seeing, I like to think of almost AI as sort of the emotional support animal for a lot of requesters, in that, one, it gives them the idea to make requests. They put into ChatGPT, hey, I was denied this right to know request. What can I do? And it tells them, did you know that there's the Office of Open Records and you can submit an appeal? And then the part so that increases the number, but we're also getting a huge increase in what these requesters are submitting. Remember I said before, they have to do very little on that appeal form. They can just say, I think these records do exist, so I do want to appeal this. Now they will put in the language from the ChatGPT and say, this agency denied it because they said the records doesn't exist. And they will give pages and pages of legal argument that they claim they should provide to our office to prove why they think they are justified in getting these records. Here's the problem. AI is currently, it may never be a very good attorney. First, there's a lot of nuance in these things. But most basically, it gives wrong information. It hallucinates court cases that have never existed. It takes court cases that exist, but pulls quotes that don't exist. It is a big sloppy mess. They call it slop. It's a lot of slop. Or it'll pull out a quote that kind of sounds like a slam dunk from a court case on its own, but it's not. It has nothing to do with the case at hand, because you need an attorney to review this. And people are just taking verbatim, copying and pasting in there. And we can tell this because of the language you use. And also, on at least one occasion, they forgot to delete the AI commands that say, would you like me to tell you more? So this is a challenge we have yet to face in terms of the volume. And instead of our attorneys having to review 2 or 3 sentences, they're having to review 2 or 3 pages of messy legal analysis. And I've tried it myself. I put in things and kind of see how it works. And more recently, I was rear-ended a few weeks ago, and I think my car is going to be totaled, unfortunately. And I've tried this. I put in ChatGPT, said, this is what happened. Do you think I'm totaled? Like, yeah, I think you're totaled because of blah, blah, blah. And I said, would you like me to write something for you to challenge the insurance company for how much money you get? It's like, oh, I wasn't even thinking that, but okay. And it always asks you questions. Would you like me to do this? It never stops because it wants you to get hooked in. So anyway, this is a challenge that we're seeing. I imagine it'll come to requests. We're seeing it in some cases in requests. So someone will type in, I want to get a lot of police records on this, and it'll tell you all the records to ask for. And in terms of the solution, there's not a magic wand solution right now. The whole world is grappling with this. So stay tuned. There is some legislation perhaps to limit or even ban the use of this, but it is a challenge. This is not a way where it's saving money in government. It is actually costing a lot. Okay, turning back to police departments. One of the big differences, if there's a criminal investigatory record, those appeals go to the district attorney. All other appeals for police departments come to our office. And here's some kind of cheat sheets on what types of records are public. I did the stoplight. Green is public, yellow is maybe, and red is no. Home addresses for individual officers, not public. And then names, employment application, discipline and misconduct reports, social media posts about department business it depends on the situation. It depends is an attorney's favorite response. I'm not an attorney, but they love to say it depends. So for all of these, it's kind of a case-by-case basis. Names in particular, if someone's undercover, it would not be released. Here's some other ones. Okay, police blotters and incident logs, always public. Department financial records, always public. And then things that are maybe are policies and procedures, mugshots, information on individual officers, which I just went through, shift rosters, and then things that are prohibited by law are vehicle accident reports and incident reports. Some common reasons for denial, we say, is that it's a criminal investigatory record. That's probably the most common thing. Pennsylvania is unique in this way in that criminal investigatory records are protected in perpetuity. Some states have like a 10-year sunset or 25-year. In Pennsylvania, you could ask for criminal investigatory records from the 1960s and they could be denied. And so that is one thing. And then there's also non-criminal things like an investigation into something happened with an employee. Those are also can be protected in perpetuity. A security threat, often people want certain records or security footage or policies and procedures that the police department is able to effectively demonstrate that it shows a threat to security. 911 recordings, I've always more of those. Those are protected, and obviously you're not going to get people's social security number or personal cell phone, that type of thing. Those are protected as well. This is in addition to there are a lot of laws. CREA, as I'm sure you all are familiar with. And one difference is there are some laws that prohibit the release of information, saying you will get in trouble if you release that. The right to know law reasons are not prohibitive. You can release some of these things if you'd like to, but you don't have to if you don't want to, but you can if you would like. So one big thing that became popular a few years ago were policies and procedures in police departments, in particular use of force policy. And those were able to be, those were exempt if the agency, the police department, was able to prove that the disclosure is a threat to public safety. So it's not a slam dunk. You can't just walk in there and say, hey, it's use of force. It's a problem for public safety. You have to really prove it. Now, what I like to sort of say as an example, when I say prove it, think of someone who's accused of robbing a bank. If they go on the stand in court and say, yes, I did not rob that. No, I did not rob that bank, and just walk off, they have not proved their case. So even in these cases, in this kind of paper trial, we call it, the police department, probably an attorney, will have to demonstrate that it's likely to threaten public safety. There was a case where there's cases it's been successful and there's cases they have not been successful. So it's important to take that seriously when you try to provide your reasoning. Shift rosters, we don't see this as much, but we saw this a lot for a while. Often, again, security exemptions are cited, often successful. It just has to be proven, and it's also case specific. And so then this one case I threw out here, city demonstrated a security threat for most of the record, but must disclose the names of the officers on duty that day. It's a big change. Now, this is going to be a bit of a theme in Pennsylvania, is there's a lot more restriction on the types of records that a lot of people like to see. That includes mugshots, body cam, and 911 calls. We are not fodder for a lot of social media posts. And mugshot thing is very recent. It was just last year that they had a big decision. It used to be mugshots were, throw them out there. And now it's very different. There are kind of 3 tiers. Counties are prohibited from releasing mugshots under CREA. So that's like a non-law enforcement agency. State police can disseminate them for a fee outside of the right to know law, though, so it has nothing to do with the right to know law. And in terms of local police departments, they can disseminate mugshots only as they deem necessary to carry out their law enforcement functions. So it is this their discretion. And I am not able to say much more about this because it is a very recent decision. And so there's not a lot of case law on it, but this is what the decision said. So that's a big change in recent years. Now, Act 22, this is the law that dictates body cam and dash cam. This was, I think, 2017. And the bottom line is we have nothing to do with it. But because we follow this issue, we know some about it. And the first thing is that it must be requested within 60 days of the incident. The police department must respond within 30 days. You can charge reasonable fees, and appeals go directly to the court. Now, all of this means that we are not like certain other states that end up on TikTok. There was a long article in a magazine recently about this concern that people will make requests for certain body cam or dash cam, particularly of young women. Getting a DUI seems to be the thing they like to get, and then they put it on TikTok and they make money off of it. And so here, so you see this moment in someone's life that is on someone's social media feed. And some states have kind of winnowed away at that by saying that you can get that record, but the person being recorded has to give your permission. And so Pennsylvania is much more restrictive. You're not going to see much body cam, if any, on social media from Pennsylvania. There has been a change, though. We've been seeing the last year actually some courts ordering release of footage. You know, it's expensive to take this kind of thing to court and fight for it. So it's not common that people, when denied access to body cam, will fight for court. But there have been two instances for the first time that did that. One was in November of last year with footage about regarding use of force and arrest of juveniles. And then there was one, and that one didn't give a lot of detail in the court decision, but this other one did. And this was a case, I believe what happened was there was a car chase where someone stole a police car that started in Ohio, ended in Pennsylvania, and the perpetrator was shot and killed by police. And the state police said it's an ongoing investigation, and the court said that was not the right decision because there's no evidence of an ongoing investigation. The person is deceased. And also there was footage released from Ohio. I think Ohio has very loose restrictions on this. And also there's footage of incident by bystanders. So there's no reason not to release it. So that they said that there was no specific security safety concerns they were not successful in doing that. So that was released. So a slight change. I still don't think we're going to have a lot of Pennsylvania action on TikTok, but there is a little bit of loosening of that. And then just a note on fees. This just was last week or 2 weeks ago where Chambersburg decided, as I said, you could charge reasonable fees. And they made the claim that the $100 as a flat fee was not reasonable, and they were losing money on fulfilling these body cam and dash cam video recordings that they had voluntarily said, yes, we will give these out. So they went from $100 as a flat fee to $125 an hour. So that is something that they changed. Now, the Crime Victims Act of 2023, we have, again, this is kind of like Act 22. We have nothing to do with this, but just to explain what it is, it's completely outside of the right to know law, is that victims or their representatives, if they're seeking civil action, can get certain police investigative records, otherwise barred by CREA. And so that is something that can be done. It's not our world, and any appeal of a denial are filed through the courts. And if you have more questions, that'd be probably your DA or the Office of Attorney General could talk more about that. All right, so I know 911 calls are not something that you all deal with directly, but I thought I'd go through a little bit in terms of what the rules are on that, because it's like what I mentioned with body cam and now mugshots. They're not something that can go out. And when I talk about this, I can't help but just mention one of my favorite shows from my childhood, which is Rescue 911, which heavily relied on 911 calls. And growing up as a child in Virginia, I had no idea. Now I do, that there are probably very few Pennsylvania 911 calls on there. And did you know that William Shatner is still alive? He is in his 90s, but remarkable. Not doing those commercials for the travel agency anymore, but he's still with us. So Pennsylvania is unique compared to a lot of states in that the recordings and transcripts and transmissions are explicitly exempt from the right to know law. And the only way you can get them is if the agency says, you know what, we're actually going to give them to you in this case, or if the agency denies and a court orders them to be released. And for a while that wasn't happening. There was a lot of unsuccessful efforts. And then the first successful one that we've seen in our tenure is the attempted assassination of President Trump in Butler County. That was the time when the counties denied the right to know law request and said it's part of a criminal investigation, and there's an explicit exemption in the law. And our office is not under the authority to overturn that. We're just kind of a pass through. So we upheld the denial, and then the judge ordered the release, as he or she said, given the unique historical circumstances of the event. So like I said, we can't do it. And one thing to note is the identity of the requester does not matter. Even if you are the person on the 911 call, or if you are, or involves your children, it's irrelevant to the decision. And this is a common theme of the right to know law. You don't get special privileges just because typically of your identity as a requester. There's one story I will share that is an exception. There's always an exception to everything, but here's one where the identity of the requester did matter, but this is why this requester did not get those records. There's a woman, I believe in the Quakertown area, who had a pet kangaroo. And I don't know why she had a pet kangaroo or how the logistics of that worked or how much land she had, but she did. And the kangaroo was taken from her. She was quite distraught, and she knew where the kangaroo was being kept, and she attempted to break into the facility. The Game Commission had the kangaroo. They then moved the kangaroo to a secret location, and she did a right to know request to get records to demonstrate where the kangaroo is being kept. And the agency claimed, and our office upheld it, that she had proven that she was a threat to the security of the building and the safety of the workers, and so she was not able to get those records. And so as far as I know, the kangaroo is still in the witness protection program and doing well somewhere in Pennsylvania. This happened again with a pet deer recently, a common theme that we're seeing. Theme, I'd say, is just two of them, but a repeat story. All right, now I'm going to go through some tips and best practices. I know this is probably more relates to your right to know officer, which may be tied to your borough or township, but they're really good things to know. One is, don't have any unforced errors. The right to know law is complicated and nuanced enough to make mistakes can make it much more challenging. The deadlines are very black and white. Unless you can demonstrate some extreme circumstance, there's going to be a real problem if you miss that 5-day or 30-day deadline, and you may have to it will automatically grant access to the records. Now, it automatically be a deemed denial and creates a lot of legal problems going forward. So just making sure that you have someone who's an open records officer who's trained and diligent, and that you always respond to a request. Now, one story I will share is I heard of a police department where there was a request for those use of force policies, and they didn't respond to the request at all, nothing. So the requester, as is their right, appealed them to our office. We reached out, we heard nothing. And when that happens, when we don't hear from an agency, we can't hear the defense. If you don't hear defense, you automatically grant. So we granted access to the records because we had nothing to go on. And then the requester took that to court and said, they're supposed to give these records. And at this point, this police department got very involved and testified and said, oh, we had someone who was an open records officer. They weren't doing a good job. They're no longer with us. And I don't know the outcome yet, but the courts initially were not sensitive to that. They said it's blaming it on somebody else is not appropriate. This law's been around a long time. The buck stops with you. You've got to figure this out. And they may have been forced to release those records, the use of force policies, because they did not engage in the process. So it's always important to respond to a request. Follow record retention rules. I don't know what the record retention rules are for your police department or your agency, but make sure you follow them. And this is kind of a double-edged sword. One, if you delete things you shouldn't be deleting and someone does a request and you say, we deleted that, it's not a great look. But on the other end, and this is something I struggle with, that if someone said to me, Liz, I'd like to have all the emails you sent about doing presentations in the last 3 months, because I am the best at deleting what we call transitory emails, like what time, here's the link, here's this. I'd have to go through a lot of emails, when if I had just kept my inbox a little more clean, I wouldn't have as many records to go through once if and when there is a request for my records. So keeping those retention rules in mind is important. Communicate with the requester. Now, you know your people. There may be times it is not a good idea to pick up the phone and talk to a certain person, but there are times when, just like in life, communicating and writing is not the best way to do it. There's a situation where someone did a request for just a ton of financial records, and the township said, oh my, this is going to take a lot of hours from my people. We're going to have to charge a lot of photocopying fees to this person. Why don't I just give her a call and see what she's trying to get at? and they spoke on the phone, and it turns out all she wanted was how much they spent on snow plowing each of the past 3 years. That's it, 3 numbers. She just didn't know how to describe the records. You have to realize that your average person does not speak the bureaucratic speak that you and I may speak, and may make a much broader request than necessary. So that's something to always consider. Another one, like I mentioned, it's not a confidentiality law. You can post things online that people seek a lot. That's two things. When somebody gets a request, so you get a request for something that's on your website, you just say, here's the link, done. And two, it also is just a good look that you are promoting transparency, that's putting things all out there. And you consider providing records you could withhold. Remember I said these are records you can provide if you'd like. This is an example I gave in that someone requested my resume. And I was appointed to this position 5 years ago. I didn't apply. There was no application process. So we could have very much denied access to this record saying it doesn't exist. We don't have Liz's resume in our possession. But I thought about it. I'm the executive director of the Office of Open Records. People have a right to see kind of my background, I think. So I removed some personal information, but did provide a version of my resume because I thought public interest outweighed any interest in withholding it. A good faith search. What does this mean? This is really important. Now, if you get a request and you look for it, the courts don't expect you to hire a forensic IT auditor to search every nook and cranny of the server, but you need to be able to demonstrate in case people appeal your denial that you looked in the likely places. The best way to do this is have someone who's in charge, the open records officer, say, hey, we got this request. If you have anything relevant to it, send it all to me. Do that and then determine if they're public. So making sure that you've looked carefully. And this is important because there have been cases where it's gone through the courts and it's been then demonstrated that the agency did not make a good faith search. They did not do enough to search. This isn't saying that they the bar is pretty high for this to be something that is found. They understand that things may be missed, but if there's evidence that they did not look at all or did not look in a remotely likely place where the records would exist, they could be charged. In another instance where someone didn't produce records, a school district can alter the requested records. So bad faith behavior can be a liability. Conclusory affidavits. This is a fancy lawyer term, but it goes back to my thing about the person accused of robbing a bank. You can't just go and say the requested email doesn't exist. You have to get more factual. Or the record is another example, it's a non-criminal investigation. You have to answer the questions. You can't just say it. You have to provide factual information that supports that statement. This is a big reason why some agencies are not successful in affidavits, and we're sitting there like, oh, they could have done this just a little bit more and you would have been close. So making sure those affidavits are not conclusory is good. All right, wrapping up, I'll be taking questions in a second, but want to mention we have a great website that's chock full of information, every decision we've ever made. So if you have a certain request for a record, you're curious if we've ruled on it before, just put it in there, the search term, and you get it. We have a guidebook. We have all sorts of trainings you can watch, and you can always email us or call us with questions. We cannot give legal advice. We can't say, yes, this is public, or do this or do that. But sometimes we can tell you, well, why don't you look at this case? And it may be a case that is similar enough to guide you. And I also wanted to mention we do have some more webinars going up. If you really like this training and want to see it again or have colleagues that would like to see it, we're doing it March 24th. And then we're doing a basics of the right to know law, which goes in much more detail generically, not just law enforcement of the process. And then if you're curious about the Sunshine Act, which dictates open meetings, that is something also that we are doing a training on in May. So with that, I am going to see if there are any questions out there.
Liz, I'll start with one. This is Chris.
Hi.
And do you have any involvement with people using, and it seems to be more attorneys, a subpoena, but from the county prothonotary to produce records? Is that a way around right to know?
No, if we've had that, I don't know about it, but we would be completely outside of subpoenas.
Okay, because it's odd and maybe somebody else in the group has dealt with them. I'm sure they have, because the prothonotary signs them and seals them as blank items, and then the people fill them in. So they pretty much ask for whatever they want. And it's just, there's a whole policy to it, but it's confusing.
Yeah, that's
Chris, we just had one of those last week, and our solicitor denied all of them and actually went to court to fight them. And we were basically successful. The judge squashed them.
Did it involve the McShane group, Brian?
No, it was a child custody, like PFA case.
Gotcha. Okay.
Thanks. Chris, can you explain again? So they send a subpoena for the prothonotary?
Go ahead, Dave.
I had one too. It was a domestic related thing where the gentleman who had a PFA against him went in and actually filled it out personally in the prothonotary's office, and they signed it. And he came here and served it on me. And our solicitor got involved and quashed the thing too. Had to submit something to one of the judges. So I don't know how prolific it's going to be, but it was an avenue that this guy tried.
All right, Liz, it's called, the heading is subpoena to produce documents or things for discovery pursuant to Rule 4009.22. And I looked it up, and I sent an email to this person. Now, he's a lawyer, so although his handwriting appears to be he's in second grade, it's dreadful. And it was asking for all these items, and it's clear it's also domestic related, which is amazing, Dave and Brian. It just seems to be a workaround. They want body camera to, I think, show, probably a custody judge, this is how they were acting or this or that. But it says that they have to give pre-notice to what they're going to ask for, and this and they came in with one piece of paper, dropped it off with the ladies out front, and left. And it was like, well, nothing else was done correctly. So yeah. I just emailed them that, hey, you haven't followed any of the steps, so I'm not going forward with anything until that occurs. And it's always last minute. It's a custody hearing Wednesday, and this is Monday. Can you have it done? Even though it says I have 20 days and things like that. So it was new, and I was just curious. So
yeah. That's the first I've heard of that.
Yeah, I think they all realize that these aren't available under Right to Know or Act 22. So I think this is kind of like their new end run. And I worry there's probably departments that are, filling them out and they're maybe being successful.
Right. Rob, I see you had a question. Go ahead, please.
No, Chris, I was just going to comment. In a previous life, I used to get these all the time, and I would just take them to the solicitor. They'd file a motion to quash, and oftentimes it didn't even end up in court. They knew they weren't properly doing it.
Gotcha. Thanks. Courtney, that may be something semi-related, that Crime Victims Act that Liz was talking about. I know when Sean brought it up, he was going to put out some policy, and Liz referred that it would be under the district attorney or AG, that we could get a little more specific guidance would be great.
Yep, I can send you guys something. Right now, all of those requests should be coming to me and not to you guys, and then I can sort through them and decide what we're giving and not giving. We've had a few attorneys try to get creative and file those to get around even grand jury subpoenas. So,
wow. Liz, sorry. Does your basic right to know training go over what can be released if a record includes part of a juvenile? Name, date of birth, obviously date of births are out, but names, or even a lot of our reports have just initials. It's CR instead of Chris Robinstein if I'm a juvenile, but people could figure it out easy enough.
Yeah. It will not, but we had a case like this recently. So Chris, I can send you, I can't, like I said, I can't give you legal advice, but I can send you some interesting cases that deal with that.
Okay, that'd be great. And anything that I get, I'll share with a group. So that'd be helpful.
Yeah.
Anybody else have any questions for Liz?
You can always reach out if it's a week or months or a year from now and you're thinking, what did Liz say? You can always feel free to ask, and we can try to be as helpful as the lawyers let me.
Understood. We really appreciate you taking the time to meet with us, and that you were able to fit us in.
Hope was helpful.
Yes, ma'am. Thank you.
Right. Thank you. Bye-bye.